Assalamualaikum and hi everyone. Today, our group will present the legal issue arising from the case involving Lola Lorele and Cambodia Angkor Air. Lola was travelling from Phnom Penh to Malaysia after covering the 2023 SEA Games. Her flight was delayed because of heavy rain. During boarding, she slipped on the wet aircraft stairs and suffered a neck injury and also several broken bones. Her medical expenses reached 341,000 ringgit and she later developed a fear of airports and flying. In Malaysia, the main legislation involved is the Carriage by Air Act 1974. This act gives effect to the Warsaw Convention as amended at The Hague 1955 and the Montreal Convention 1999. We will explain the case using the ILAC method, which stands for issue, law, application and conclusion. The first issue is to determine which international conventions applies to Lola's claim. Under Article 1 of both conventions, the convention apply to international carriage by air. The court must examine the place of departure and destination state in the passenger's contract of carriage. Malaysia became a party to the Montreal Convention in 2008. However, Cambodia only became a party in 2025. Since the incident happened in 2023, Cambodia was not yet a party to the Montreal Convention. If Lola bought a separate one-way ticket from Phnom Penh to Kuala Lumpur, the Warsaw Convention as amended at The Hague will most likely apply. This is because Cambodia and Malaysia were both connected to the Warsaw system at the time. However, if Lola bought one return ticket beginning in Malaysia, travelling apply. This is because Malaysia will be both of the place departure and final destination, while Cambodia will only be an agreed stopping place. Therefore, the court must examine Lola ticket and booking information. The conclusion is that the Warsaw Convention most likely applied to a separate one-way ticket, while the Montreal Convention may apply if it was part of one complete return journey. The second issue is whether Cambodia Angkor Air is liable for Lola's physical injuries. Article 17 of both conventions provide that an airline is liable when passengers suffers bodily injury caused by an accident on board the aircraft or during embarking or disembarking. In the case of Air France v Sachs, the court explained that an incident is an unexpected or unusual event that is external to the passenger. In Lola case, the aircraft stairs were wet and slippery after the heavy rain. This was an external condition because it did not come from Lola's bodies. Passengers normally expect the boarding stairs to be safe. Therefore, the slippery stairs may be considered an unexpected or unusual event. Lola also suffered clear bodily injuries, including neck injuries and several broken necks. Her 341,000 ringgit hospital bill was directly connected to the accident. She was also in the process of embarking. She had already been called for boarding and was climbing the stairs leading directly into the aircraft. Therefore, she was following the airline's boarding instruction and was under its control. The airline may argue that the airport or ground handling company managed the stairs. However, the stairs was still being used as part of the airline boarding process. The airline may later claim contribution from the airport operator, but this does not automatically remove its liability towards Lola. In conclusion, Angkor Air is likely to be liable under Article 17 because Lola suffered bodily injury caused by an accident during embarking. I will now pass the presentation to the second presenter.
Thank you. I will continue the issue of the flight delay. The issue is whether Cambodia Angkor Air is liable for 2-hour delay caused by the heavy downpour. Article 19 of the Warsaw Convention and the Montreal Convention state that an airline may be liable for damage caused by delay. However, the airline may avoid liability if it proves that it took all necessary or reasonable measures to prevent the damage, or that it was impossible to take those measures. A passenger must also prove actual damage caused by the delay. For example, additional hotel expenses, the cost of another flight, loss of income, or missing a connecting flight. In this case, the delay was caused by heavy rain. Bad weather may make airport and flight operation unsafe. Therefore, the airline can argue the delaying the flight was necessary to protect the passenger and crew. The facts also do not show that Lola suffered any financial loss from the delay. She did not pay for accommodation, miss another flight, or lose income. She only waited at the airport for about 2 hours. Therefore, her claim for delay is weak because mere inconvenience is normally not enough. However, the delay must be separated from the wet stair accident. The rain may justify the delay, but it does not justify allowing passengers to use unsafe stair. The next issue concerns the defense available to the airline. Under Article 20 of the Warsaw Convention, the airline may avoid liability if it proves that it took all necessary measures to prevent the damage. Article 21 also allows the court to reduce compensation if the passenger's own negligence contribute to the injury. Cambodia Anchor Air may argue that the stair wet because of the weather, which was outside its control. However, the airline already knew that there had been heavy rain. Therefore, the risk of wet stair was foreseeable. The airline could have inspected and dried the stair, placed warning sign, used non-slip surface, provide staff assistance, or delay boarding until the stair was safe. If the airline failed to take this step, it would be difficult for it to prove that it took all necessary measures. The airline may also argue that Lola contributed for the accident. For example, it may claim that she was running, she was using a phone, or ignoring warning sign. However, none of this fact is mentioned in the question. There is no evidence that Lola acted carelessly. Therefore, the airline is unlikely to succeed with the defense of contributory negligence. The next issue is the amount of compensation. Under Article 22 of the Warsaw Convention, as amended at The Hague, the airline liability for each passenger is normally limited to 250,000 francs. In Malaysia, this commonly is amount stated as RM48,000. However, under Article 25, this limit will not apply if Lola proved that the airline acted intentionally or recklessly while knowing that damage would probably happen. Ordinary negligence is not enough to remove the limit. Lola would need strong evidence that the airline knew the stair were dangerously slippery but still allow passengers to use them. For example, her case would be stronger if another passenger had already fallen, staff had received warning or complaint. Based on the fact given, the airline appears negligent, but there may not be enough evidence to prove reckless conduct. Therefore, if the Warsaw Convention applies, Lola compensation may remain limited to RM48,000. If the Montreal Convention applies, Lola position is better. For an accident in 2023, the first level of liability was 128,821. Special drawing right. Lola may claim her medical expenses and other proven losses, including further treatment, loss of income, rehabilitation, cost, pain, and suffering, and loss of enjoyment of life. However, she must support this claim with evidence such as medical report, receipt, and salary record. In conclusion, the airline is likely to remain liable because the danger was foreseeable and there is no evidence of contributory negligence. The amount of compensation will depend on whether the Warsaw Convention or Montreal Convention apply. I will now pass the presentation to the third presenter.
Thank you. I will explain whether Lola can claim compensation for her mental anguish and fear of flying. In Eastern Airlines Incorporated v. Floyd, the court held that Article 17 of the Warsaw Convention does not allow compensation for purely mental or psychological injury when there is no bodily injury. However, Lola's situation is different because she suffered a neck injury and several broken bones. Her mental suffering developed after a serious physical accident. Her claim will be stronger if a doctor or psychiatrist confirm that she suffers from a recognized condition such as PTSD, anxiety, or depressions. Evidence of counseling, medications, or psychiatric treatment will also support her claim. Lola is a sport reporter and her work may require regular air travel. If a fear prevents her from traveling and affect her employment, she may also claim related financial losses. However, she must prove that these losses were caused by the accident. Therefore, Lola cannot claim successfully for a simple feeling of fear. However, a recognized mental condition supported by medical evidence may form part of her compensation. The next issue is whether Lola can start legal proceeding in Kuala Lumpur. Article 38 of the Warsaw Convention allows claims to be brought where the airline normally resides, where it has its main place of business, where the contract was made through establishment, or at the place of destination. Article 33 of the Montreal Convention provides the same for grounds. It also provides an additional ground based on the passenger principal and permanent residence, subject to a certain condition. In this case, if Kuala Lumpur was stated as the destination in Lola's ticket, the Malaysian court would have jurisdiction because Malaysia was the contractual places of destination. She may also sue in Malaysia if she bought the ticket through an establishment of Cambodia Angkor Air in Malaysia. If the Montreal Convention applies, Lola may also rely on Malaysia as a principal and permanent residence, provided that the airline operates services and carries on business in Malaysia. However, her Malaysian nationality alone is not enough. She must satisfy one of the jurisdictional grounds provided by Convention. The final issue is the time limit for starting legal action. Article 39 of the Warsaw Convention and Article 35 of the Montreal Convention provides that the right compensation is extinguished if the action is not started within 2 years. The period is calculated from the date aircraft arrived, the date it should have arrived, or the date the carriage stopped. Since the accident happened in 2023, Lola had to begin legal proceeding within 2 years from the relevant date. She should not wait until she has fully recovered before filing the case. She may start the legal action within the 2-year period and later submit additional medical report about her future treatment or long-term condition. Lola also cannot avoid this rule by calling her claim negligence, breach of contract, or occupier's liability. Her claim against the airline remain governed by the International Air Convention. To conclude our presentation, Lola has a strong claim against Cambodia Angkor Air for her physical injuries. The words there were unexpected, external condition, and the accident happened while she was boarding the aircraft. Her claim for the flight delay is weak because she did not prove actual financial damage and the airline may justify the delay based on safety. If the Warsaw Convention applies, her compensation may be limited to 48,000 ringgit unless she proved intentional or reckless conduct. If the Montreal Convention applies, she may have a better chance of recovering her 341,000 ringgit Malaysia, medical bill, and other proven losses. Lola may also claim for a mental condition if it is supported by a proper medical evidence. She most likely be able to sue in Malaysia if Kuala Lumpur was the destination stated in her ticket. Most importantly, she must start the legal action within strict 2 years period. That is from our group. Thank you.